Good afternoon and welcome to Real Estate Syndications, Navigating Minefields for the Unwary. I am Elizabeth Dryden. I am a partner in the real estate department of Ervin, Cohen, and Jessup, and I am also the co-chair of the Beverly Hills Bar Association Real Estate Section. I am here with my partner, Chris Manderson, who in addition to being a partner at Ervin, Cohen, and Jessup, is the co-chair of the Business, Corporate, and Tax Department. Now, before we get started, I want to kind of set the lay of the land for y'all. What we're going to do here is we're separating this presentation into two parts. The first part goes over when your client is the one who wants to organize a real estate deal. The second part covers when your client is an investor in a real estate deal. And what we're going to do is we're going to go through the first part, and then we're going to take a pause. And you have a little Q&A box on our Zoom function here, so you can put your questions in the Q&A. And after the first part, we'll pause and go through those questions. And then after the second part, we'll pause and answer questions regarding the second part or the entire presentation. All right, with that, I will let Chris take it away.
Thank you, Elizabeth. So we have designed the deck and the presentation here around what we think is a pretty common scenario where you're sitting in your office or somewhere and a client calls you and says, hey, I've got this great idea. I want to form an LLC, put it together to do some real estate project, and I want to sell interests in the LLC to raise capital for the project, and that's how we're going to get this thing funded, and everyone's dreams are going to come true. So the first warning light that should go off when you get that call is, are you selling a security? And in that common scenario where the client is putting together an LLC or some other entity, sometimes a limited partnership, the answer is almost certainly yes. The reason that it's a security is as laid out in the Securities Act of 1933, also known as the Securities Act or the 33 Act. There's a very detailed definition of a security in the Securities Act, which we won't read through, but you're going to be selling a membership interest in a corporate entity, and that is by definition going to be a security. It's also important, and there's a big trap for the unwary here, in that a security is not always some sort of a corporate instrument. A security can be a lot of things, and the government has taken the position that all kinds of different things are securities, including there's a famous kind of quaint case from the 1940s, the Howey case, that gave us the Howey test, in which investors purchased a row of trees in an orchard, citrus orchard, and a contract to service those trees and share in the profits. The Supreme Court, coming out of the Howey case, decided that that was a security, even though it wasn't a stock or a bond or anything, because people made an investment, there was an expectation of profit, and the outcome was dependent on the efforts of others. So the takeaway here is, if you hear about some sort of interest that's being sold where there's an expectation of profit and the outcome is dependent on other people's efforts, you should assume that that is a security and you need to analyze it as such. So that being said, you tell your client, yes, it sounds like you're selling a security and you need to be in compliance with securities laws. So what do you do next?
So under the Securities Act, every offer and or sale of a security is required to either be registered with the Securities and Exchange Commission or qualify for an exemption from registration. Now, the very particular and very important nuance here is offer, not offer and sale, offer. So that means there's no testing the waters. Your client cannot go out and post something on Instagram saying, hey, I have this wonderful idea, who's in, and see if any investors bite, and then either register or qualify for an exemption. That offer itself has to be registered or qualify for an exemption. So that's a very important distinction. So, what do people do? What are our options here? Registration. Registration is, that's an IPO. That is a very expensive endeavor. It has a lot of costs, delays, and regulatory burdens. And for the most part, what Chris and I are talking about during this presentation are single asset syndications. Chris will touch on multiple asset syndications in a moment, but really what we're talking about is single asset syndications. So an IPO is just too expensive for these projects. So what do people do? They qualify for an exemption. What's our exemption here? Private placements under Section 4A2 of the Securities Act. Private placements are placements that do not require registration, that are to pre-selected individuals instead of publicly on the open market.
So your client has decided, or you have advised the client that they need to do some sort of a private placement under 4A2. 4A2 under the Securities Act is a transaction by an issuer not involving any public offering. That's what the code says. What does that mean in reality? It could mean a lot of things. What the SEC has done to be helpful is they created Regulation D to provide a non-exclusive safe harbor under 4A2 and an objective set of standards that you can follow. And if you follow those standards carefully, then you can qualify for a private placement exemption. Rule 4 under Reg D is available. It's not very commonly used because it's limited. It's limited to $5 million raised in a 12-month period, and that's typically not enough capital for a major project. So what do people generally use for these types of syndications? Typically, they're coming in under 506B or 506C of Regulation D. It's important to understand a few things about these. They provide for potentially an unlimited amount of capital being raised and an unlimited number of investors, hypothetically, if you follow the rules. As an example of a very large one, prior to its IPO in 2018, Uber actually raised $2 billion using Reg D and in a bond offering in order to fund the company through the IPO. So in order to qualify for this, you've got to follow the rules of the road for either 506B or 506C, both of which have a couple of different nuances.
All right. So how do you qualify under Rule 506B? Well, first of all, it's very important, no general solicitation. So you cannot advertise broadly to the open market. What can you do? You can advertise, you can solicit offers from folks that are known to you, from friends, from family, from folks that are introduced to you that you know maybe through your professional associations or networks. So there are abilities, you do have the ability to get new investors. If you have an existing investor list, you can always go out to your existing investors as well. Under Rule 506B, there are no limitations on offering size, as Chris mentioned before. So you can get as much money as you want, which helps a lot because, as Chris was saying, 504 has that $5 million limit, which doesn't really get you very far in the real estate world right now. These securities can be sold to an unlimited number of accredited investors. We'll go through in a moment what makes an accredited investor. Another requirement is that you have to have knowledgeable persons available to answer questions. So if the investors have questions about the structure, about the deal, anything, you have to have somebody who is there who can answer them. If you have a private placement memorandum or a similar document, which we'll get more into later, which sets forth substantially all of the information that would be required in a registration statement, then you can include up to 35 non-accredited investors. So the flip side of this is if you have no non-accredited investors, you don't have to have a private placement memorandum. That is a technicality. We never, ever recommend that. That is not best practices. Because the PPM, those documents, those disclosure documents, they protect the issuer, not the investors. And so we always recommend that you have something there to protect you. All right, who qualifies as an accredited investor? Well, actually, before we get into that, let's take a step back and talk about the purpose of accredited investor. What is the idea here? The idea is that an accredited investor is a sophisticated investor that can perform his or her own financial analysis and risk analysis. And the idea is you want to protect investors with limited financial knowledge from investing in risky investments and potential losses that they cannot withstand. So there are a few different ways of how you can qualify as a accredited investor. This list here is not exhaustive, and you only need to check one of these boxes, right? So first of all, we have any individual that earned income that exceeded 200,000 or 300,000 together with a spouse in each of the prior 2 years and reasonably expects to receive the same for the current year. And this is essentially using income as a metric for financial knowledge. Similarly, any individual who has a net worth over $1 million, either alone or together with a spouse, hits this accredited investor. But the important nuance here is you need to exclude the value of the person's primary residence. And I've actually had this come up where I've had a client call me and talk about wanting to raise money for accredited investors. And it's like, oh, well, with the value of their house, we're in LA, this is easy. Not so fast. That's excluded. Another way to qualify as an accredited investor is if you're the issuer's director, executive officer, or general partner. And the idea there is that you have expertise and you have knowledge about the project. Similarly, a financial professional holding a FINRA Series 7, 62, or 65. And again, that goes back to the concept of financial knowledge. And we'll talk more about this in a little bit, but issuers generally ask investors to make representations as to their accredited status.
So moving on to what's the difference between 506B and 506C, a couple of things. One is general solicitation is permitted under 506C. So you may have seen some sorts of services that will promote an investment on a website or something, or are raising money through general solicitations of some type. Those are using 506C. And 506B, of course, prohibits general solicitations. And in the case of 506C, all the investors have to be accredited investors. 506B, as Elizabeth mentioned, would permit up to 35 non-accredited investors. The fact is, if you're raising substantial money for a real estate project, it's probably not worth your trouble to deal with non-accredited investors, but you are permitted to under 506B. Another difference between B and C is that in 506B, you're entitled to rely on representations by the investors as to their accredited status. Under 506C, you as the issuer have to take reasonable steps to verify that they actually are accredited, so you can't just rely on them. Extremely important point here, the trap for the unwary. A single unaccredited investor can disqualify an offering from qualifying under the 506C safe harbor. And so there is a tremendous premium on the diligence that your client is going to have to do to make sure that they're dealing with accredited investors only. In that Uber example, they raised an enormous amount of capital. They weren't raising that from dentists and hockey players. That was being raised from Goldman Sachs's private wealth funds and sovereign wealth funds in the Middle East and that sort of thing, which of course were accredited. Moving on to
Chris, I actually have a question here.
Sure.
Okay, so say we're not Uber and say we do have individual investors. What sort of reasonable steps would the issuer take? What are some examples to verify that the investors are accredited investors?
Well, you would start with asking them to make representations as to their accredited status, and then you need to verify, in diligence why they actually do qualify. So there are third-party services that do provide this diligence for you if you want to hire them, but you essentially need to verify the reason why they say that they are accredited.
Right. So if I check the box because of my income, then maybe they would want to see a W-2 versus if I say I have a license, then maybe they'd want to see evidence of that license that matches up why I'm saying I'm an accredited investor.
That's exactly right, or brokerage statements if you're relying on your assets or some sort of valuation report for illiquid assets. But the reasonable steps, of course, when lawyers talk about reasonable, it's always subjective. But the issuer is going to have to do something to verify. And given the stakes being so high for losing the 506C exemption, and in the case of an unaccredited investor, your clients need to take this very seriously.
Right, right. Because with the unaccredited investor and you're doing general solicitation, then you're in trouble.
Yeah, then you're in trouble because you won't qualify for the 506B exemption having done a general solicitation.
Right. Asking for a friend. This came up recently in one of my clients.
Don't do it. Okay, so moving on to slide 9, just a couple of issues here. We aren't going to go into any great detail here, but there are 2 layers of securities regulation. There's federal, all of the rules that we were talking about so far, the 33 Act, those are all federal laws and regulations. There is an overlay of state laws and regulations that you have to consider in each state that you're selling securities into. If you're doing a non-506 private placement, in other words, you're not following the rules of 506 and relying on the 506 exemption, then you don't get the benefit generally of federal preemption, and you have to consider complying with the regular state blue sky laws. Very important, the second bullet point, though, if you do comply with Rule 506, this is covered security under federal law, which gives you the benefit of federal preemption. That does not get you entirely out of state compliance. States may require you to pay a fee, and they may require you to file something, like some states require you to file your federal Form D in the state as well. In part that is to get you to do something and give them money. But you always have to consider this, and what states are relevant. That would be states that you've actually sold into. So a large private placement, you might sell into 50 states, but this becomes a compliance issue that you've got to think about. If you've got one person in North Dakota who's giving you $50,000, is it worth the compliance in North Dakota that you're going to have to consider?
Chris, nuance question here before you move on. You said states that you've sold into. What do you mean by that?
States where people have purchased securities. So you'll want people to represent as to which state they claim residency in, or entities which state they claim residency in. And you would generally be deemed to be selling a security into that state if they purchase.
Okay.
So moving on, funds, we are not going to open this can of worms in this presentation. We are talking generally about single asset real estate matters here, single asset LLCs. However, just be aware, if your client comes at you with a slightly different fact pattern and says, I have a great idea, I want to raise a fund, and then I'm going to go buy a bunch of multifamily, or I'm going to buy a bunch of Class B commercial or whatever, and there's not a specific asset that is being raised around, you are going to have to consider whether the Investment Company Act is implicated or the Investment Advisors Act. And those acts generally require somebody raising a fund and managing a fund and getting fees from a fund to register with regulators as an investment advisor. There are some exemptions under the 40 Act and under the Investment Advisors Act. We aren't going to get into them now, but the takeaway for you is if the client wants to talk about raising a fund, that is a different animal, and you've got a whole different set of compliance issues that you're going to have to investigate related to that.
Chris, can I ask a couple of questions here before we move on? Because this comes up for me a lot. Clients really like the idea of raising funds. And then, because we do say here, class of real estate assets. So does that mean that generally when people raise funds, they tend to raise it for a certain class, like office, or even like more specific, Class B office? Or do they mix and match within real estate funds?
It could be anything. It could be a fund that would invest generally in real estate and other types of assets, securities or whatnot. The issue isn't so much what they're investing in specifically. The issue is are they raising a fund in general and making money off of the management fees and the deployment of the capital, as opposed to a single LLC that owns a single piece of property.
And I've always heard for real estate funds that one of the trickiest things with the funds is that the disclosure requirements.
Yes.
It's very difficult for real estate. Oops. I think I just moved us forward. Let me see. Did I just do that? Give me 1 second. Make sure I'm on the right slide.
Slide 11.
Okay, great.
Yeah, you got it.
I coughed on my hand on the button. All right. So we've gone through the analysis. Your client has decided to do a private placement. So how do you document that? You're going to have a series of documents, and a lot of the things actually in these documents is kind of duplicative. So if we're talking and you're like, hey, that sounds like there are representations in the subscription agreement that are similar to the LLC agreement, you are correct. A lot of this is duplicative because the whole idea is you want to protect the company, protect the issuer. So you generally have a credit investor questionnaire or subscription agreement and a private placement memorandum or a similar document. It could be a private placement memorandum, an offering memorandum, an investor deck. These things come in lots of shapes and sizes. So those are your investment documents. And then in addition to that, you have your limited liability company agreement. And that's the governing contract of the company. Excuse me. So going back to the credit investor questionnaire or the subscription agreement, generally the questionnaire is just a pure question and answer kind of thing. The subscription agreement will typically include a questionnaire. It'll also include representations as to the investor's accredited status. And the way a lot of clients will do this as well is the subscription agreement will also include a joinder to the limited liability company agreement. And the reason why they do this is because for a lot of clients, a lot of folks that raise money, their investor list is proprietary. And they don't like sharing that because they've taken years to build up those relationships, right? And so a prime example of when this would maybe be passed on is for the lender, right? It's always the elephant in the room is the lender. And the lender likes to see the organizational documents. They want to follow control from the fee owner, the entity that owns the dirt, right, up to a warm body. So they want to follow that control chain. And so what we'll often do is instead of giving them the limited liability company agreement with all the investor signatures and the investor schedule, is we'll include in the limited liability company agreement a certificate executed by the manager saying, everybody has signed and everybody, reps to these, to the accredited investor reps, something along those lines. And that way we keep that information confidential. Not to go too far down this rabbit hole, but it is something that's very important if you're raising the money. Lenders have their know your client processes that they have to comply with, KYC. They're going to do that on anybody who has control. So if your client, if he's the principal, they're going to do their KYC on him. They also do it on investors of a certain size. So generally it's 20% or higher, or maybe more than 20% for domestic investors and more than 10% for foreign investors. And that's something to be aware of, because if you have this wonderful angel investor who's coming in with 30% and giving you all this money, that's great. But now the lender is going to come and need to know a lot of information about them. There's going to be a lot of forms they have to provide. And investors don't always like this. So it's something that you do need to get ahead of and be aware of. All right, so then private placement memorandum or similar documents. These essentially from the issuer side, this is where you put in all of the risk factors. You list everything that could go wrong, because as Chris said, like this is what protects you as the issuer. And then the limited liability company agreement, we all know what those are, and they just govern the rights under the investor's rights under the LLC agreement and what the manager can and cannot do.
So you have done the deal now. the issuer has sold the securities, and what do you do after the sale is completed? The final step of compliance with the SEC is filing a Form D. The Form D is a very simple form. It's a couple of pages long. It's filed electronically with the SEC and is required to be filed within 15 days after the first sale of securities, keywords being first sale of securities. Some of these deals close all at once. Some of them have some open period. For 90 days, the issuer can continue to sell more securities, but that Form D needs to be filed within 15 days of the first sale.
Chris, can I actually, before we go too far into that, can I ask you a question? Because this also comes up a lot with my clients too, right? And the first sale. So what counts as a sale? Because generally what my clients will do is we'll have the fee owner who actually acquires the property. The sole member of the fee owner will be our syndication vehicle, this LLC, and they'll be out talking, not advertising. They'll be out interacting with their pre-selected investors, with their private investors, and then at some point before closing, they'll start accepting money. Right now, is that the first sale, or is the first sale when we acquire the property and the deal's a go?
So the sale is the exchange of a security for money. And so a lot of this depends on structurally how the deal is set up. But if the issuer is accepting money, it can be accepted into escrow, until a certain tipping point is reached. No.
No, we don't accept into escrow, because escrow, if there's any money coming from anybody other than the borrower or buyer, they require third-party escrow instructions. So you'd have to do that for all of your investors, and it's just, no one likes it. It's not good. So it goes into a bank account, the bank account for the LLC, for the syndication vehicle.
Okay, so if at that point they are actually issuing the security, they receive the money and they issue the security, that's the first sale. So it is not when all of the capital is accumulated and the property is purchased. The underlying property itself is not really relevant to this. It is when is money exchanged for the actual security and the security issued by the issuer.
Okay, can I throw another little wrinkle into all of this for you?
Sure.
So if we start collecting money, the entity has been formed, we start collecting money, but oftentimes we don't date our LLCs until the date of closing. What counts as the sale then?
Well, you mean date the LLC agreement?
Yeah, that's right.
I mean, yeah, the LLC agreement can be dated at any time. I mean, LLC agreements get amended and redated all the time, right?
That doesn't have any effect.
Yeah, that's not the issuance of a new security. Okay. The question is, if somebody is buying an LLC interest, it's when do they become a member of the LLC, and that would be the exchange of the security for money.
Okay, this is very helpful to know. Thanks, Chris.
Okay, so a couple of other minor things about this. When you file electronically, you have to get Edgar codes in order to be able to file with the SEC. You have to apply for those. It's kind of a pain. It takes a little bit of time. And so you want to plan in advance for this. If you're doing a private placement and soliciting investors, that process generally takes several weeks. So you want to make sure that somebody is responsible for that. Couple of other things. The failure to file a Form D, which happens all the time. It's very, very common that the issuer gets the money and then they're off running their project and forget to file a Form D. The SEC has taken the position that the failure to file a Form D is not going to defeat your ability to use Rule 506 and conduct a valid private placement. However, a couple of things. If you discover that they failed to file a Form D, it's a good idea to remediate that, even if it's late, and get it on file anyway. It shows good faith. The other thing is that if you are sort of a serial offender and continuously fail to file Form Ds, the SEC can can crack down on you and prohibit you from using some of these private placement exemptions. That is not generally done simply because somebody failed to file Form D. That's kind of like getting a speeding ticket. Generally, the SEC will use jurisdictional hooks and penalties of that nature when somebody has done something much, much, much worse. So if the SEC is busting you for failure to file a Form D, it's probably because you did something very bad, and it's a little bit like nailing Al Capone for tax evasion. All right, moving on, state filings. I think that we covered this already. In general, you have to look at whether there are state filings required. Very often, states will require you to file the Form D with the state. Some states have their own forms that may apply, but generally, every time you're selling into a state, you need to consider what you're going to have to do in that state as well as your federal compliance requirements. Okay, so moving on to slide 14, if your client screwed up and did not properly conduct the offer and sale of the securities, the investors have a remedy. They can essentially require the issuer to repurchase the security, repay the purchase price. In some cases, you may get interest and attorney's fees and other costs. Again, these are not ordinary course situations. These are situations often after something has gone wrong, the project has failed, and lawyers go looking for remedies. You know, they might then consider whether a valid private placement was conducted. So you might actually have this rescission remedy. In practical use, it may or may not be useful to you. It may be a way to sue someone, whether there's any money to recapture on rescission. You know, if it's a failed project, there probably isn't. But this remedy does exist, and so your issuer needs to be aware that if they screw this up, people can come hypothetically looking for their money back. If there's been fraud or bad faith, the SEC might get involved. In some cases of fraud and bad faith, they might try to look through and get officers and directors to repay, and the SEC and the states may impose penalties and fines.
Chris, can I ask you a question on this?
Sure.
How does this normally happen? How is it the SEC investigates, an investor makes a claim? How does this normally come about that there's an issue with the offer or sale of the security not being done properly?
Yeah, it's generally not going to come from the SEC because the SEC doesn't typically monitor private placements. You know, the only notice that they have that a private placement occurred is often a Form D, unless it is a very, very large private placement, you know, somewhat like the Uber private placement that we were talking about. But in general, you know, these private placements of this nature are going to be under the radar. And so it's generally going to be an investor that is going to bring this to the attention of the SEC if the SEC gets involved at all. And it is an investor right of action. So an investor might bring a lawsuit in court, you know, with or without the SEC.
Okay, good to know. All right, so that is the end of part one. It does not, do we have any questions? It doesn't look like we have a whole ton. We have one question about legal fees that I would say to our Briskin. Maybe you can email us and we can talk to you about that. Anybody else before we move on? Going once, going twice. All right. So we will get started in part two. So part two, this is the other side. Your client is the buyer. So this time your client comes to you and says, oh my goodness, I have this amazing opportunity. You know, my sketchy cousin, my brother, maybe somebody they know professionally, it doesn't always have to be somebody sketchy, is doing a real estate deal that I want to invest in. I need your help. Generally, they're very excited too. So a big part of our job here is to make sure that, you know, they understand the lay of the land and that they're protected.
So we touched briefly on these issuer documents in part one. You're typically going to see a few things. If you're representing the buyer, you'll see accredited investor questionnaires and subscription agreements. You'll also see the private placement memorandum, and you'll see the LLC agreement. So starting with the accredited investor questionnaire and subscription agreement, the subscription agreements first are not always used. They sometimes can be skipped in a situation involving an LLC where the representations and the covenants that would normally be in a subscription agreement just are put into the LLC agreement. Along with accredited investor representations. That's fairly common in LLCs. In some other types of entities, C Corps, which aren't typically used for real estate, a C Corp, you will pretty much always see a subscription agreement. But a subscription agreement is a pretty simple document in concept. It involves a contract for the purchase and sale of a security. So in that agreement, the issuer will covenant to sell the security for money. There will be reps and warranties made by the issuer, that these securities will be validly issued, that all corporate action has been taken to authorize them, and so forth. On the buyer side, the buyer will represent that they are purchasing in good faith and not for resale, that they are purchasing this for their own account. That they are an accredited investor, and the accredited investor questionnaire often is an exhibit to the subscription agreement. And they will also make representations sometimes about where their funding is coming from, which is helpful for KYC requirements. But in the end, we're talking about a document that's maybe 4 or 5 pages long. And all that it should do is govern the purchase and the sale of the security. It does not govern the ongoing relationship between the parties once that transaction is done. So that contract should be fully performed when the security is sold and that piece of the deal is done. That's important because you really want to see boilerplate here. You don't want to see anything unusual. You don't want to see necessarily ongoing covenants of performance on either party. You don't want to see any unusual restrictions on parties for buying or owning any other assets. Those ongoing governance and covenants should be in the LLC agreement, or if it's a C Corp, should be in some other type of document. So anyway, this should be done once the security is bought or sold. The accredited investor questionnaire we talked about, it's usually a couple of pages long. It will list a number of ways that you can be accredited, and you will make certain representations. You might check boxes, or your client might check boxes on which requirements they meet to make them accredited investors. So if you're advising this client, take this very seriously. Especially if it's a 506C and the client is going to be scrutinized. Sometimes people do get, so-called opportunities from their, disreputable cousins or whatever, and they just want to check a box because they think they have some great opportunity to get rich. But, they are making representations that are very, very important in the scheme of the deal, and they need to be very serious and be able to back up whatever they've said that makes them accredited.
And I'll say just really quickly here, because Chris mentioned that subscription agreements aren't always used. And I would say that's probably true. Most of my clients just do, a PPM accredited investor questionnaire and an LLC. The subscription agreements I see those less frequently.
Okay. And that's a good point. And even if you don't have a standalone subscription agreement, you would expect to see a lot of the substance of that subscription agreement show up in the LLC agreement. People will make representations and covenants that they're purchasing for their own account. Something that reminds me, something we haven't talked much about in the presentation, private placement securities by definition are restricted securities. That's one of the key elements that is different between a registered security that has been subject to an IPO that freely trades in a market and a private placement security. So your clients need to know that they are not going to be able to resell these. This is an illiquid investment. There is not necessarily a time frame for the return of your capital or any profit, which we'll talk about a little bit later in the presentation. But your client is going to sign on to restrictions, and there will be big legends in capital letters governing the securities that will say that they are restricted and may not be resold. Is it possible to sometimes resell restricted securities subject to certain restrictions? Yes, but in general, there's no market and no liquidity for them, and that's one of the key elements of private placements. So moving on to the private placement memorandum itself. So this is not something that you're going to see written out in Rule 506. There's no definition of a private placement memorandum. There's no federal law that says you have to use a private placement memorandum. What is it? It's an offering memorandum describing the transaction, soup to nuts. It should describe the transaction itself. It should describe important terms such as the financials of the deal. It should describe the team and the management fees. You know, this is a sales document. It's a promotional document. It's important for the issuers, as we talked about already, because it helps protect the issuers to show that they gave all the information that the investors could possibly want. If you are on the buy side of this deal and you're advising a client, it's very, very important that you make sure that your client very carefully reads this PPM, because it is a sales document and not necessarily a legal document like an LLC agreement. It's going to be more accessible to the layman. And it also will include risk factors that should apprise the client of exactly how many different ways they can lose all their money. Very, very important. So your client needs to understand this. It's going to make your life easier if the client understands how the management fees work and how much comes off the top and how the waterfall is described, you know, what the expected financials are. But it is very, very important for you to have an informed client. That also helps validate a private placement if the client has been fully informed, even though, as Elizabeth mentioned, accredited investors are deemed to be able to do their own homework and come to their own conclusions. You as counsel, you're also looking for consistency of terms between the PPM and the LLC agreement. So if the PPM describes the management fees in one way and the LLC agreement differs from them, that's one of the things that you're going to have to square up with the issuer's counsel. But in general, you know, this is the document that I would urge my clients to spend the most time looking at, because it's going to lay out everything for them. Moving on then to the LLC agreement. So the LLC agreement, I mean, an LLC is just a partnership, and an LLC agreement is a contract that governs the partnership. You know, it's a very fancy sort of partnership, but that's what it is. We're going to assume that everybody in this seminar has a familiarity with LLC agreements and how they work, how they're governed, and so forth. So we're just going to talk about a few specialized issues here. One is tax. Every time an LLC agreement hits my desk, the first thing that I always look at is whether the investors are entitled to minimum tax distributions. Because an LLC is taxed as a partnership, the members of the LLC are deemed to be partners for tax purposes. Gains and losses are passed through to the investors. It is possible for an LLC to be taxed, to make an election to be taxed as a C Corp. Elizabeth tells me that never, ever happens. She shakes her head. She says, no, that does not happen. And it wouldn't make a lot of sense in a real estate deal, but it is hypothetically possible. And I do sometimes see it in corporate for tax reasons that aren't worth getting into. Anyway, minimum tax distributions hugely important because the members of the LLC are the ones that actually have to pay the taxes to Uncle Sam. However, unless the contract gives them a right to minimum tax distributions, they can get a tax bill and not have the money to pay it. So every LLC agreement that you ever look at, you need to make sure that the client is going to get money every year to pay their taxes. If they don't have a minimum tax distribution requirement, then you need to advise your client, and that could be catastrophic for tax purposes. Depreciation and losses can also pass through to the clients in the early years of a real estate investment. Very often they generate a lot of losses. And so those can be beneficial to your client. They can use them sometimes to mitigate other gains or other income. So they can be great in the early years, even when the project's not making money. But that also is something that you need to talk about with your client about how are they going to hold it. If it is going to pass through some losses and eventually some gains, is it being held by the client in a tax efficient manner? Is it held individually? Is it held in some other entity that has other gains and losses that could be matched with these profits? So, like I said, tax is the single most important thing, I think, when you first look at the LLC agreement. That being said, people enter into LLCs not to be taxed, but to make money, and sometimes have to invest more money. So Elizabeth is going to tell us about capital calls.
Yeah, and actually first I'd like to start talking about the initial capital contribution, which that is a requirement. And if you commit to making the initial capital contribution and you don't, the penalties for that are draconian. So be aware of that. And then beyond that, there are additional capital calls, right? And the question is, are the investors required to contribute additional capital? They aren't always, right? And so if they aren't required to contribute additional capital, what we'll see is there will be a sort of dilution, but it'll be like a true dilution, right? So if everyone else invests more and you don't, obviously your membership percentage will decrease, but it'll decrease on a dollar for dollar basis based on the fact that you didn't put in more money. However, if there is a requirement for additional capital calls and you do not do that, the repercussions can be quite severe. This is a trap for the unwary, because often, clients get very excited. They want to get in the deal, they want to get started, and they don't look down the road, right? And these dilution provisions can be quite severe. Your membership interest can get sliced in half, essentially. And it's been really interesting. Everyone, I'm sure, is aware of how tumultuous the real estate industry has been over the last few years. I'll say prior to that, I almost never saw these provisions enacted. I never saw them come into play. In the last year, I've seen these come into play so frequently. And what's the reason? Well, okay, costs across the board are increasing. Debt service is going up. Cost of utilities is going up. I'm seeing that even with my home. My utilities are going up. The cost for capital expenditures, everything, all the costs are increasing. They've increased so significantly that a lot of these were not modeled back when the projects were built. So they need additional capital. And actually, when my clients come to me, and my clients tend to be the owner operators, when they come to me and let me know that this is happening, I have a little Excel spreadsheet that I plug in all the numbers, and they tell me what they think the numbers are. Then I plug in my numbers, and we essentially sort of see if it matches. But this is happening more and more frequently these days, and it's kind of just a sign of the times, unfortunately.
Okay, so moving on to a couple of the other issues in LLC agreements. So an LLC is run by a manager. It's it's important for clients to understand that an LLC is not a democracy. Corporations aren't democracies, and they're not run like them. Part of the reason that a client is generally going to be investing in something like this is because they believe in the team and they believe in the project, and there's an agency concept where the manager is really the one that's going to run things on a day-to-day basis, and so clients aren't generally going to be voting on what subcontractor to use or any operational aspects of this. Generally, voting rights are major decisions, and it's important to understand that this is not even that different from a normal corporation. And in a corporation, a C Corp, if you're a shareholder, you have the right to vote in an annual meeting once a year, maybe for the election of directors, the ratification of auditors, and that's about it. And if you're a shareholder, you have the right to distributions when they're declared, and to vote in elections and inspect certain documents, and that's it. So when you're in an LLC, similarly, there isn't much that you actually get to vote on. And unless you're bringing a very large proportion of the capital, if you're a minority holder, you shouldn't really expect to have a lot of governance power anyway. But LLCs are also a little bit unique in that voting rights are limited to major decisions, some of which are listed here, issuing additional membership interests or creating additional class. That dilutes the holders. That's a rational thing for them to want to vote on. Amending the formation document, amending the LLC agreement, is something that the members are generally going to have a right to vote on. And so these are very often done by majority vote. So again, if your client owns 2% of an LLC, they really shouldn't expect to be able to sway this. There are some things that the manager is able to do without a vote. They tend to be fairly ministerial, to reflect the issuance of units that had been transferred to a new member, or to reflect inconsequential changes, or to satisfy certain orders of government bodies. But again, things that are fairly ministerial. But anyway, when your client is going into this, it's important to understand that in general, they are going to be a passive investor. They're going to be treated like a passive investor, and they will have the influence of a passive investor.
I was gonna say, I would like to add that I would, again, I'm normally on the other side of that. I would advise your client of that like very clearly as well, because I've been on the other side where, I have some clients with very established track records, and then we have these little investors that have all of these questions and all want to make all of these changes. And, we're happy, or my clients are happy to answer the questions. As we saw, that was a requirement that they be, have knowledgeable people available, but we're not going to change the form of LLC agreement. And it's kind of frankly a waste of like time and energy for everyone. They just need to understand, that that's not how this generally works, unless, like Chris said, they're a significant investor.
Well, there's an important transactional point here if you are counsel to that guy, because if your client is a pain, and they're not bringing a lot of money, it would be very rational for the issuer to say, we don't want a gadfly here who's going to cause a lot of trouble and bring us $50,000. So it's very important that you advise your client if they want to get rich off this investment and have all their dreams come true, that they need to play ball.
All right, so now the waterfall, how your client gets his or her money back. Probably the most important piece of the LLC agreement, right, Chris?
Yeah, absolutely. Show me the money.
Show me the money. So this is a sample from a deal that I did last year, and I'm just going to walk us through it because there's actually a lot going on here. Okay, so this is distributions of available cash. So it's subject to Section X distributions with respect to taxes. So we see those minimum tax distributions come first that Chris was talking about before. Available cash shall be distributed to the members by the manager as and when determined by the manager in the following order of priority. So before we even move into our actual waterfall piece, let's take a step back. So we already talked about the distributions with respect to taxes. So let's talk about available cash. What is available cash? This is net cash. This is cash after obligations. And the obligations are debt service, any impounds or reserves required under, because again, that lender, they're the, what is it, the 2,000 ton, they're the ape in the room, right? The lender is there. We have to make sure that any required impounds or reserves under your loan documents come first. And under your loan documents, the impounds will be for real estate taxes and debt service, and the impounds will be for, possibly like insurance, CapEx, things along, the reserves will be for insurance, CapEx, things along those lines, right? Any additional reserves that might be required by the manager might think are safe and good to have. Any fees owing to third parties, any fees owing to the manager, all of that comes out first. And then you're left with available cash. Okay, so then we go to as and when determined by the manager. So they're under real estate deals. Generally, there's not a requirement for monthly or quarterly distributions. And part of that is because, first of all, the manager wants to have as much control as possible, but also lenders don't like to see guaranteed payments. If something looks like a guaranteed payment to a lender, that's going to look like something that primes their debt service, and they don't like that. All right. So then moving, and actually, before we get too far, whoops, goodness, give me 1 second. I'll get us back there. Okay, back to the important one. All right, and another piece here that's important, again, going back to the timing issue, is your client needs to understand what the model for this project is. Right? So some real estate deals are cash flow models, meaning the idea is that you invest and they'll start shooting off cash. Some are capital event models, meaning, and those are typically more like your value add models, right? You buy the asset, you make changes, you reposition it, and then maybe it starts cash flowing towards, like, as you're trying to sell it, but really you expect to start heading through your waterfall upon either a sale or refinance. Refinances are looking a little bit iffy, obviously, these days, because we know how everything's going. But that's a capital events model versus a cash flow model. And it's very, very important that your client understands what the expectation is, because you would hate to have your client be in a situation where they put up a bunch of money and expect to get cash back right away. All right. So then the first piece is your preferred return hurdle. So the members get money back. Oh my goodness, we're running out of time. And so the members will include the manager. The managers will generally have a percentage interest. You want to see that as a member because you want to see that your manager has some skin in the game. And lenders often require this as well. So you get a 7% preferred return. The preferred return is return on your investment. It's percentage of your unreturned capital. So that's first tier. Second tier is the members, again, and the manager is a member. The manager has two hats under this LLC agreement. Sometimes there's called it's called a managing member. I prefer to separate them to make it very clear. They have two different roles. And so then you get your money back. Great. Finally, we go to this third, and here you'll see it's split 75% to the members and 25% to the manager. Well, that 25% to the manager's not invested 25%, right? So that's what's called the promote. And that generally happens on the back end. That happens when most often we really don't get through this whole waterfall during operations. That'll generally happen at a capital event. And that promote is essentially the money that the manager gets for sourcing the project and then running it well so that they operate efficiently and do what they say they're going to do. That's the money that they make. And here there's an internal rate of return, IRR, hurdle of 12%. And IRR is a way of comparing the future value of an asset in today's dollars. In other words, it's interest earned on each dollar invested. And this is really commonly used in real estate. There's a very complicated calculation for this. Nobody actually does it by hand. The Excel has like a functionality that allows you to calculate this, but it includes a lot of assumptions. And then finally, we see our last tier, which is 50% to the members, again, including the manager for their actual percentage interest, and then 50% to the manager. And so that's also a promote tier. Oh, manager fees. All right. So manager fees. The important thing to know about manager fees is that they come prior to distributions of available cash. Now, this is absolutely standard, but a lot of clients don't understand this. It is completely market. Examples are acquisitions fees, asset management fees, loan origination fees. You can read all of these. What you need to do as counsel is, one, make sure that they understand, your client understands that these fees come out first, and then make sure that they match what's in the PPM. Now, what's very, very difficult about this is what is market varies greatly depending on the type and the size of the asset. It is so difficult to tell unless you're in, unless you're in the weeds on these LLC agreements every single day, like I am. It's very difficult to keep your finger on the pulse. So that's something to be aware of. And it just moves around a lot, especially with today's environment.
Okay, and the last slide, and we're running out of time. We've covered this previously. What happens if the private placement is not properly conducted? If you're on the plaintiff side of this, your remedy is rescission, a right to make the issuer buy the securities back. And that right may or may not be helpful to you, depending if the project is cratered. There may be no ability to do a buyback, but in any case, that right does exist. So with that, I think we're out of time. And with regard to questions, you can see our emails there, our phone numbers. We are more than happy to talk with you further if you would like to contact us. Elizabeth, I'll give it over to you to wrap it up.
Sure. So thank you, everyone. Thanks for being here with us. We really enjoyed it. Just some upcoming programs that the real estate department has. On February 27th, we join forces with the real estate department, real estate section, with the bankruptcy section, creditors and debtors, issues between landlords and tenants during bankruptcy. And then on March 16th, Lawrence Jacobson does his annual year in review for the major real estate cases of 2022. So we hope to see you there. Thank you so much and have a great afternoon.